If you had a problem, why did you spoil the life of the lady, sir?
No, my lord. ಅಲ್ಲ ಮದುವೆ ಆದ್ಮೇಲೆ ಮೂರ್ಛೆ ರೋಗ ಬಂದಿರೋದು.
ಮದುವೆ ಆದ ತಕ್ಷಣ ಮೂರ್ಛೆ ಹೋದ್ರ?
After
ಮದುವೆ ಯಾಕಾದ್ರಿ?
ನನ್ ಮಗನಿಗೆ ಜಾಸ್ತಿ ತೊಂದರೆ ಕೊಡ್ಬೇಡ, ಅವನಿಗೆ ಟೆನ್ಷನ್ ಕೊಡ್ಬೇಡ.
ಎಪಿಲೆಪ್ಸಿ ಇದೆ. Why did you?
After marriage.
After marriage ಬಂದಿರೋದ?
After marriage. Single doctor ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Single episode ಅಂತ ಇದೆ after marriage.
Husband Milord sir
ಏನಿದೆ?
ಕನ್ಸೀಲ್ ಮಾಡಿದ್ದಾರೆ. He spoiled the life, Milord. He spoiled the life of innocent lady.
That is fit for divorce.
The gravity here that he has
concealed, no problem,
Milord.
that's correct, all that is fine.
Dowry demands are also there, Milord.
Petition, my lord.
Appeal for the respondent number 3 in this case, please, Milord. I filed my wakalat today. I am given to learn, Milord, that a copy of the IA application is not served on to the council.
Yes. Which applications?
Vacating stay, please, Milord.
What's the matter, sir?
No, this is a 498A case, my lord. After filing this writ petition, this petition, wife filed the divorce and maintenance. In that,
After filing?
After giving the complaint, she filed this is the foundation stone for the divorce.
Foundation stone?
Yes. Because
ಯಾವ building?
Because she want to go out of the wedlock. That's why.
Foundation ಸಾಕು, stone ಯಾಕೆ?
Yes.
Yes.
Sorry. In that petition, my lord, husband has given a consent for the decree of divorce. Only alimony part court has to decide. Now it is for the argument stage. Only epilepsy.
ಅಲ್ಲಿ settle ಆಗುತ್ತಾ?
Yes, my lord. Court has, he is paying the entry maintenance. Alimony on the permanent one, that case will be closed, my lord.
If that case is closed, will this case get closed?
But only it requires hearing of the case, my lord. I can demonstrate. It is a.
You are the husband?
Yes. It is a misuse of the law.
ಹೌದಾ? ಹೇಳಿ.
Engagement stage date ಅನ್ನ cause of action ತಗೊಂಡಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಮದುವೆ ಆಗಿ?
Hardly she led 1 year ಆಯ್ತು. Hardly she led 3 months.
1 year ಅಂದ್ರೆ 3 months ಅಂತ ಇದ್ದೀರಾ?
ಮದುವೆ ಆಗಿ 1 year ಆದ್ಮೇಲೆ she filed the MC case. ಈ ಚಾರ್ಜ್ ಶೀಟ್ ನಾವು ತಗೊಂಡು ನೋಡಿ.
You want time?
No, Milord, I'll canvass, Milord.
Yes, sir. Yes, come on, merits.
Kindly see, my lord, FIR, annexure E.
ಬೇರೆ ಪೇರೆಂಟ್ಸ್ ಇದಾರ, ಹಸ್ಬೆಂಡ್ ಒಬ್ರೇನಾ?
Parents ಇದ್ದಾರೆ.
Parents will quash.
Milord,
Even husband also,
I'll come on that point.
Wait. Yes.
No, even for the husband. So your lordship judgment is there.
Ayyo, no problem, sir. Tell me, sir.
Rendered several, referred several.
ಹೌದಾ? Yes.
FIR, annexure E, my lord. See, top first 21/4/2004 ದಿಂದ 11/1/2005 ಅವ್ರ ಮದುವೆ ಆಗಿರೋದೇ May 24.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಇಲ್ಲ ಅಲ್ಲ?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಲ್ಸೋ.
ಆಲ್ ರೈಟ್.
annexure K.
ಈಗ ಸ್ಟೇ ಆಗಿರೋದು ಹಸ್ಬೆಂಡ್ಗೂ ಆಗಿದೆಯಾ? ಹೌದಾ?
By Dhanlakshmi, by referring that
Dhanlakshmi
judgment is.
What Dhanlakshmi?
I gave it.
Who is Dhanlakshmi?
Sorry, Dara Lakshmi.
Dara Lakshmi
Narayan. I relied on this judgment.
Oh, sorry, sir. Yes.
So, nothing is elicited in the 62 is the kindly see the page number 62. ಮೈಸೂರು ನಗರ ಕುವೆಂಪು ನಗರ ಪೊಲೀಸ್ ಠಾಣೆ ಸರಹದ್ದು ದಟ್ಟಹಳ್ಳಿ 3ನೇ ಹಂತ ಡಿ ಬ್ಲಾಕ್ ಮೇನ್ ನಲ್ಲಿರುವ ನಂಬರ್ 2416 ವಾಸವಾಗಿದ್ದ ದೋಷಾರೋಪಣಾ ಪತ್ರ ಕಾಲಂ 12ರಲ್ಲಿ ಕಂಡ ಆರೋಪಿ ಒಂದರವಧಿ 21/4/24 ಸಾಕ್ಷಿ ಒಂದರವಧಿ ದರ್ಶಿನಿ ಕನ್ವೆನ್ಷನ್ ಹಾಲ್ ಹೋಟೆಲ್ನಲ್ಲಿ ನಿಶ್ಚಿತಾರ್ಥವನ್ನು ಮಾಡಿಕೊಂಡಿದ್ದು, ಈ ಸಮಯದಲ್ಲಿ ರವರ ಮನೆಯವರು ಆರೋಪಿ 1 ರವರಿಗೆ ವರದಕ್ಷಿಣೆಗೆ 10 ಗ್ರಾಮ ಚಿನ್ನದ ಉಂಗುರ ಮತ್ತು ಒಟ್ಟಿಗೆ 5,000 ಕೊಟ್ಟಿರುತ್ತಾರೆ. ನಂತರ 35/24 ಆರೋಪಿ 1 ರವರು ಸಾಕ್ಷಿ 1 ಮೈಸೂರಿನ ವಿಶ್ವೇಶ್ವರ ನಗರದಲ್ಲಿರುವ ವಿಶ್ವರ್ಣ ಪಾರ್ವತಿ ಕಲ್ಯಾಣ ಮಂಟಪದಲ್ಲಿ.
Complaint.
Milords, the petitioner number 1, Milords, is suffering from one seizure disorder. That's mesial temporal sclerosis, Milords.
What is that?
This is, Milords, sclerosis.
Yes.
That, Milords, the very specific definition is a person loses his control over himself. And this could not have happened, Milords, right after the marriage. Petitioner number 2, Milords, was a policewoman herself. Petitioner number 2 and 3, Milords, have misrepresented, and this factum, Milords, has been concealed. right after the marriage, my lords, the very statement that would be given by the petitioner number 2 and 3 is nan maganig jaasti tondre kodbeda, avanig tension kodbeda. Anywhere.
Will that amount to 498 days, sir?
No, my lords.
Then-
Anywhere that they had to go, they would accompany.
So what? Yes.
Misrepresentation then, my lords.
That won't amount to divorce correct agide adu.
Divorce ಅಲ್ಲಿ there also we have agitated.
That's all right. Yes.
As far as my lords, petitioner number 1 is concerned, my lords.
Hmm.
Petitioner number 2 ought to have, my lords, very specifically informed that this is what he is going through, knowing full well that that is his condition.
Correct.
Engagement ಆಯ್ತು, right after that 39 days ಅಲ್ಲಿ ಮದುವೆ ಆಗಿ ಅವರು it was very specifically mentioned from their side, my lords, force ಇತ್ತು. So
498. Husband will not quash.
all right, my lords.
But may I submit? If that is the case, liberty may be given to the husband after disposal of the MC case to approach this court.
Alla that you, whatever liberty you
It may
have,
be
you have.
please.
Charge sheet ಆಗೋಗಿದೆಯಲ್ಲ ಈಗ.
Charge sheet ಆಗಿದೆ, but nothing is.
ಮತ್ತೆ ವಾಪಸ್ ಬರಂಗಿಲ್ಲ ಇಲ್ಲಿ.
ಹಾಗಲ್ಲ. But this
Discharge
very-
ಹಾಕ್ಬಿಟ್ಟು you filed discharge before the court, discharge reject
only
ಆದ್ರೆ
is
ಬರ್ಬೋದು.
A1 my lord, discharge ಆಗಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅದು ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ, but ಇದರಲ್ಲಿ really if there is have a stuff and produced some material, even now police have not followed the Supreme Court guidelines. They have not called after complaint. They haven't called.
The petitioners accused 1, 2 and 3 are before the court calling in question proceedings in CC 21 of 2025, CC 102 of 2025 registered for offense punishable under will prior lida madam. Heard so and so. Facts in brief germane are as follows. Before embarking upon the consideration of the issue in the list, I deem it appropriate to notice the relationship between the protagonists in the list. The second respondent is the complainant, wife of the accused number 1, petition number 1. The second and third petitioners are father-in-law and mother-in-law and father-in-law of the second respondent complainant. The complainant and the first petitioner get married on get engaged on 21/4/2024 and eventually get married on 30th May 2024. Soon after the marriage, it transpires as relationship between the couple, i.e. the accused number 1 and the complainant would would flounder. On the floundering of the relationship, the wife sets the criminal law into motion by registering a crime in crime number, crime number.
My lord, shall I pass? Sorry for the interruption. Shall I pass the judgment, your lordships?
ಯಾವ judgment?
Issues of-
ಅಯ್ಯೋ ನಾನೇ I'll follow it, don't worry. Yes.
So even for the A1 also,
No
this
problem.
498 does not attract, my lord, because of the epilepsy. As you lords, except
So
for other.
what he says is confirmed,
This,
epilepsy ಇದೆ.
but
Why did you?
after marriage. that
After
was-
marriage ಬಂದಿರೋದಾ?
ಹೌದು. After marriage. Single doctor certificate ಕೊಟ್ಟಿದ್ದಾರೆ, single episode ಅಂತ ಇದೆ after marriage. I can produce more.
Produce those documents, sir.
ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ, it is single episode.
No.
Specifically
If
observed.
you had a problem, why did you spoil the life of the lady, sir?
No, my lord. ಅಲ್ಲ, ಮದುವೆ ಆದ್ಮೇಲೆ ಮೂರ್ಛೆ ರೋಗ ಬಂದಿರೋದು.
ಮದುವೆ ಆದ ತಕ್ಷಣ ಮೂರ್ಛೆ ಹೋದ್ರ?
After.
ಮದುವೆ ಯಾಕಾದ್ರಿ?
ಅಲ್ಲಿ ಗೊತ್ತೇ ಇಲ್ಲ.
ಮೂರ್ಛೆ ಹೋಗ್ತೀನಿ ಅಂತ ಗೊತ್ತಿರಲಿಲ್ವಾ?
ಇಲ್ಲ, ನಾಟ್ ಎಟ್ ಆಲ್ ಡಿಟೆಕ್ಟೆಡ್, my lord.
Then
In the medical certificate ಅಲ್ಲಿ ಇದೆ ಎಪಿಲೆಪ್ಸಿ ಅಂತ. ಫಸ್ಟ್ ಎಪಿಸೋಡ್ ಅಂತ ಡಾಕ್ಟರ್ has referred specifically.
next episode ಯಾವಾಗ ಆಯ್ತು?
ಅಲ್ಲ, it shows that post marriage ಅಂತ. It is what is not hidden disease. ಗೊತ್ತಾಗಿರೋದು ಅದು ಡಾಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ is very clear. When he admitted, then only it came to know that it's the first episode. Therefore, even for
All right.
498.
No problem. Anyway, divorce ಇದೆಯಲ್ಲ, you can
ಅಲ್ಲ,
take
ಅದರಲ್ಲಿ
it.
but 498 attract ಆಗಲ್ಲ ಸ್ವಾಮಿ. They have to prove ಅಲ್ಲ.
We'll see, yes. The petitioner setting the criminal law into motion by registering the crime against the accused herein, the petitioners 1, 2 and 3, by registering the complaint on 21/11/2024, which becomes a crime in crime number 895 of 2024. The police conduct investigation and file a charge sheet against all the accused. Filing of the charge sheet is what has driven the petitioners to this court in the subject petition. What is there against the husband also?
Husband, my lords,
ಏನಿದೆ?
ಕನ್ಸೀಲ್ ಮಾಡಿದ್ದಾರೆ. He spoiled the life, my lords. He spoiled
Correct.
the life of
That
innocent lady.
is fit for divorce.
Also is there, my lords.
That is fit for divorce.
Correct,
but,
my lords, but I did
ಸುಮ್ನೆ
not,
crime ಯಾಕ್ ಬಿಡ್ಬೇಕು?
I did not canvass on the point of physical assault also. That also is there, my lords. But this, the gravity here that he has,
He has concealed,
He has
no problem,
concealed,
that's
that
correct, all that is fine.
dowry demands are also there, my lords. Adu ide.
ಅವ್ರಿಗೆ ಎಪಿಲೆಪ್ಸಿ, ಅವ್ರೇನ್ ಡೌರಿ ಡಿಮಾಂಡ್ ಮಾಡ್ತಾರೆ?
Petitioner number 2 and 3. That is why I told him, petitioner number 2 and 3 gu beda. Let it continue against petitioner number 1, please, my lords.
For the satisfaction of, no, ಇಲ್ಲೇನಾಗುತ್ತೆ, ಕ್ವಾಶ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ತೊಂದರೆ ಆಗುತ್ತೆ ಅದಕ್ಕೆ. ನೀವು come back.
Yes, my lord.
Yes, the so and so. The filing of the charge sheet is what has driven the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner S.V. Desai would contend that there is no allegation that would meet the ingredients of the offences so alleged against these petitioners, even to its remotest sense. Therefore, the first petitioner is said to have suffered epilepsy after marriage. And therefore, on these course, the crime must not be permitted to continue. He would further contend that the proceedings for divorce is at its fag end, and he be reserved in the event this court would come to conclude that the accused number 1 must face proceedings. He should be reserved liberty to knock at the doors of this court if there is after the proceedings for divorce. The learned counsel representing the respondent complainant would, however, refute the submissions in contending that there are allegations against all the accused. Therefore, the further proceedings must be permitted to be continued against the accused, as the demand of dowry runs through the complaint and the summary of the charge sheet. The learned learned HCGP also would toe the lines of the learned counsel appearing for the complainant and seeking dismissal of the petition. I have given my anxious concern so and so. Agota madam, so and so. Therefore, narrated facts, relationship between the parties, the date of marriage, and the date of institution of the proceedings is not in dispute. The complaint comes to be registered on 1/11/2024. Since the entire issue now triggers from the registration of the complaint, I deem it appropriate to notice the complaint, page 24 to 26. The police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 62, 63. A perusal at the summary of the charge sheet, a perusal of the complaint and the summary of the charge sheet would clearly indicate that the allegations against the parents are omnibus, vague, and demand of dowry is not specifically stated. And demand cruelty meted out by them on demand of dowry is not even stated. Therefore, permitting the proceedings against these petitioners, against the accused number 2 and 3, the mother-in-law and the father-in-law, would become an abuse of the process of the law and run foul of the judgment of the apex court in the case of Kashkan Kaushar versus State of Bihar, 2022 SSC Online SC, page 162. Which is again reiterated in the later judgment of the apex court in the case of Aarti Mehta versus State of Madhya Pradesh, 2026 SCC Online SC, page 933, the para 21 to 47. The second judgmentally, para 21 to 47. In the light of the law, the apex court holds that mere omnibus allegations, both in the complaint and the summary of the charge sheet of demand of dowry, would not become that the court should permit investigation in cases of investigation, trial in cases of charge sheet being filed against the parents of the accused, parents of the husband, while it is for the husband to defend the action. In the light of the said circumstance, permitting further proceedings against the parents of the accused number 1, the mother-in-law and father-in-law of the complainant, would become an abuse of the process of the law and result in miscarriage of justice. Therefore, the proceedings against the two must be obliterated. Insofar as the husband is concerned, it is open to the petitioner to avail of such remedy as available in law, as the complaint and the charge sheet would clearly indicate that further proceedings are necessary to be continued against the petitioner. However, it would be subject to the proceedings in divorce in the event the parties would come to a settlement of the proceedings. It is open to the petitioner to approach this court yet again.
Much
ordered according.
Grateful, my lord.